In this video, we will deal with the matter of discounts under competition law and when to consider these anti-competitive and thus infringing to Article 102 of the EU Treaty. In a separate video, we will go much more detailed into the economic side of discounts, including why companies use them in the first place. We will only touch upon this lightly in this video. While in principle this is only relevant for companies in a dominant position, the lectures have wider implication. A non-dominant undertaking might be a victim of anti-competitive discount, originating from dominant undertakings. In narrow markets, small companies might also be dominant, such that it should be never assumed that companies always know their status. Article 102 prohibits abusive behavior and provides a non-exhaustive list of what is considered abusive. As seen from the text, none of the examples refer to discounts directly. The review of discounts, therefore, rests on other theories of harm, which could be exclusionary, discriminatory, or involve tying, depending on the principle allotted to them. Discounts could even be abusive vis-a-vis those who do not benefit, hence discriminatory. Equally important is to understand that discounts often are pro-competitive or benign from a welfare perspective, and therefore require a careful balancing of opposing interests. As already indicated, it would be too simplistic to consider discounts as anti-competitive per se. All companies, even dominant companies, utilize different forms of discount systems. In reality, discounts are so common that you often fail to notice how the unit price varies across products and services. Some discounts are reserved for members or students, while others are available if you buy larger quantities. For example, a large soda versus small soda at the cinema. Often, consumers expect discounts and sales to a level where the line between Black Friday and a zombie apocalypse movie becomes blurred. I leave it to you to identify which of these pictures matches with what. Understanding why companies, including dominant undertakings, want to offer discounts involves two different stories, where only one is anti-competitive and thus warranting condemnation. The anti-competitive explanation revolves around a foreclosure strategy, where the discounts are used to create an artificial loyalty. This loyalty could be directed at denying the competitors access to the customer in general, even particularly attractive customers, either for the purpose of excluding them permanently from the market or to discipline them into relaxing the competition pressure. However, there is an alternative explanation as people's ability to pay differs. Some are shopaholics, burning every cent they earn, while others are misers. In reality, it is not even a question about shopaholics versus misers, as all people have a different willingness to pay for products and services, and thus an individual reservation price. This provides for the downward sloping demand curve, where demand is a function of the price, and high prices normally translate into low demand and vice versa. We have dealt with this in a separate video. Some companies address this challenge by offering a broad program with different sub-brands to target the buyer's reservation price. Skoda, Bentley, and Porsche are examples of brands produced and sold by the same group, while others use discounts or bundles to differentiate the price, reserving the lower price to members or consumers willing to buy extra or shift their purchases to a special time. Therefore, discounts are also an instrument that can be used to expand the market by meeting those customers unwilling to pay the full price. Embedded in this discount might even be a welfare-enhancing component, where additional consumers are allowed to buy the product or service. The alternative explanation has policy implications, as it's too simple to consider discounts as anti-competitive per se. Some discounts could even be pro-competitive and/or welfare-enhancing. Only truly anti-competitive discounts should be condemned, and then it should rest with the enforcers to establish this. It would also be misleading to use the term loyalty, as discounts are not granted in exchange for loyalty. Discounts are granted to the disloyal consumers, most likely to leave the dominant undertaking or the competitors. Anti-competitive discounts could also come in many forms, and should be viewed and potentially condemned against their effect rather than form. Having established the basics, we will now turn to how to deal with discounts in practice, which, as it shall be demonstrated, is a somewhat complex issue. It follows from Hoffmann La Roche that discount agreements that create an artificial loyalty and serve as proxy for formal exclusivity agreements are prized as such. From Michelin 1, it follows that the matter is decided against all the circumstances and the effect, the latter being the ability to foreclose competitors. However, if discounts somehow reflect payments for service, for example, sales promotion, it would fall short of the concept of loyalty discounts. Having concluded that effect, not form, matters, some variation of the traditional anti-competitive discount can be identified. These include classics, such as individualized target discounts, where they are conditioned upon the meeting of specific turnovers with aggregated elements, almost like a toxic cocktail, where the thresholds were naturally fixed at a level, making it unlikely that products were sourced from the competitor, and the aggregating nature creating a strong sucking-in effect. Even some more unusual discounts can be condemned under this standard. For example, the granting of free freezers or cash payment if they somehow are able to create a foreclosure risk. Presuming that space at a small kiosk is limited, it would be unlikely that more than one freezer would be installed. Reserving freezer space for the producer's ice cream could thus create a foreclosure. However, practice has also created openings for some exceptions. Cost reduction can be passed on, allowing for the use of discounts to incentivize the consolidation of orders or the shifting of non-time sensitive orders if practical. Further, against a settlement from 1990, it might also be possible to use aggregated individualized target discounts if calculated against a short interval. This is somewhat logical, as payment for acquisitions across, for example, a month, normally are consolidated into one invoice. The settlement accepted 3 months, but it should be invoked with some caution if a foreclosure nevertheless appears plausible. Additional principles are available from the 2009 enforcement paper, including principles and elements feeding into all the circumstances test from Michelin 1. Top slides discounts where the discount was only allotted on extras is only to be considered abusive if the marginal price fails to cover the dominant undertaking's average avoidable costs. Moreover, the same applies to unconditional discounts allotted under a standardized theme. This was an approach followed in post-Denmark 1 by the Court of Justice, which gave more substance to the submission. The enforcement paper also outlined how to review combo and aggregated discounts, both assessed against an equally efficient competitor's ability to match the effective price and thus remain viable. This can be illustrated by the following example. Assume a dominant cinema wanted to offer a combo offer of soda and popcorn, both available separately for €3, but sold in combination for €5 and thus discounted by €1 if acquired jointly. The effective unit price for the extra soda or popcorn would thus be €2, and presuming the competitors could match this foreclosure would be unlikely. Reserving condemnation to situations where equally efficient competitors potentially are foreclosed are referred to as an AEC test and have been endorsed in case law. This provides a framework for the review of discounts potentially leading to a foreclosure through loyalty or bundling, leaving us only with the issue of discriminatory discounts. Once again, Hoffmann La Roche and Michelin 1 established this basis by condemning the use of dissimilar conditions. However, neither should be read as mandating that all consumers must be offered identical terms. A reading, galvanized with one of the Deutsche Post cases, will explain that 3 forms of discrimination are covered by Article 102, of which 2 are exclusionary and 1 exploitative, thus in principle rebutting pure discrimination as abusive. This is important as we earlier observed how price discrimination was an instrument to expand demand by offering discounts to consumers unwilling or unable to pay the standard price. Of course, discrimination can still be exclusionary. However, this should in principle follow the same framework outlined earlier for reviewing exclusionary conduct, leaving us with the matter of exploitative discrimination. It remains somewhat open as to when one can identify exploitative discrimination. However, when reverting to the fundamental model, it could cover perfect price discrimination where each consumer is targeted. The Commission indicated this in 2005, but didn't follow up on the matter subsequently, and case law does not support the claim, most likely because perfect price discrimination is perceived to be unattainable, as it would require detailed information about each consumer. It would be wonderful if we could close the book here, declaring a happy ending. However, it is not that clear. Firstly, the Commission in 2005 reserved the right to condemn perfect price discrimination, as already noted. Secondly, we have a plethora of EU cases motivated by national-based discrimination that should have no place under Article 102, as the theoretical ground for condemning it is weak if available at all. Thirdly, and more problematic, one of the Deutsche Post cases specifically identified a third category of discrimination available if consumers suffered commercially. Fourthly, the emergence of the internet has given a revival to the issue of perfect price discrimination, as online platforms such as Amazon and Expedia have unparalleled information about the preference of their consumers, allowing for differentiated pricing. Recently, the European Community indicated an interest in reviewing the matter further. Fifth, the General Court in Principle rebuts the relevance of the enforcement paper and the AEC test in Intel. However, the Court of Justice did overturn the General Court, so this most likely no longer stands. It just remains unclear as to what exactly the court had issues with. The most notable feature of Intel is the absence of reference to Post-Danmark 2, a ruling largely negating the relevance of the enforcement paper and the AEC test. In contrast are the rulings rich with reference to Post-Danmark 1, a ruling incorporating many elements in the latter enforcement paper. In Recital 138 and 139, the court then established an obligation to review an AEC analysis if submitted by the defender in an abuse case, followed by more substantial guidance. The list of considerations to be utilized as part of the abuse review largely mirrors central elements in the enforcement paper, indicating that the court tacitly has utilized this. Of course, the Court of Justice confined itself to overturning the ruling and remitting it back to the General Court, such that it remains open as to what to extract from it. However, as the offered consideration can be aligned not only by the approach suggested by the enforcement paper, but also to Michelin 1, I think that the AEC test, as a minimum, is available as a defense. Dominant undertakings confronted with the allegation of offering abuse discounts can rebut this through an AEC test indicating the absence of foreclosure risk. It might be a bit premature to declare an happy ending, as it remains to be seen how Intel is applied in subsequent cases. Regardless, it should be safe to conclude that it rests with the enforcers to review discounts under the all the circumstances standard, as established with Michelin 1, indicating that foreclosure is plausible under the AEC test. Now turning to the issue of discrimination. Dissecting the wording of one of the Deutsche Post cases allows for some submissions to be discriminatory foreclosure, which comes in two forms. One form is the horizontal foreclosure of a direct competitor. This is relevant when the dominant undertaking is vertically integrated or in other ways active downstream. The object of such abuse would be to reserve the downstream market largely in the same manner as seen with margin squeeze. Void of better terms, I tend to call this horizontal discrimination. Another form is the vertical foreclosure of consumers. This is relevant when a dominant undertaking is not vertically integrated or in other ways active downstream. The object of the abuse is then to thwart competitive downstream. Void of better terms, I tend to call this vertical discrimination, or if you wish, real discrimination. Of course, the issue of how to review horizontal and vertical discrimination remains. Returning to one of the Deutsche Post cases, it follows from this that competition must be thwarted downstream through terms making one or more of the consumer suffer. Luckily, the Court of Justice in Mio confirmed that there must be an anti-competitive effect, hence that customers suffer commercially. In Portuguese airport, this was accepted when some operators, on average, were granted 22 to a 30% discount, compared to others who only received a 1 to 8% discount. So my suggestion, which needs to be applied with some caution, would be to view horizontal and vertical discrimination under the same principles applied to other forms of price abuse, including margin squeeze. That would involve considering if the upstream price charged to downstream consumers cover their long-run average incremental costs. But be cautious on overextension. In case you want to know more, a book on the matter is available. It can even be downloaded for free from the internet. And all cited cases are included with full reference. Feel free to send any questions you may have to the email, and thank you for listening.